Okay, so welcome again, everybody. This is the last session of the Young Researchers Workshop on Terrorism and Belligerency. We are at the Minerva Center for the Rule of Law Under Extreme Conditions, and we are here for a workshop on terrorism and belligerency titled Human Enhancement and Advanced Technologies in Terrorism and Belligerency. Throughout the week, we've had several presentations from different aspects, from different fields. This is a very interdisciplinary workshop. And today we are at the last day, the last session of it, and we are going to have a presentation, about 20 minutes, 30 minutes presentation by Magda Pacholska, which I will in a second introduce. You hear several people talking together. I'm the only person here with a microphone open. Hopefully it's not just people around you talking, but hopefully we can work it well. Okay, so now we will start with the introduction of Magda. Let me do it properly. Okay. Dr. Magda Pacholska is the Marie Curie Individual Postdoctoral Fellow working on the project entitled Implementing International Responsibility for AI in Military Practice within the Dilemma Project in Esser Institute. Before joining the Esser Institute, Magda worked for 2 years as a legal advisor at the Polish General Command of the Armed Forces, where she focused on the legal aspects of interoperability in joint operations. Magda obtained her PhD from the Hebrew University of Jerusalem as part of a Human Rights Under Pressure interdisciplinary research training group. And as I've mentioned before, her presentation for today is Military AI and the Principle of Distinction, a Perspective on State Responsibility. Magda, the floor is yours.
Hold on. Can you hear me now?
Yep.
I would like to share my screen. Let's see if that works. There we go. Can you see the presentation now?
Yes.
Okay, excellent. So as Ido mentioned, I'm a Marie Curie. That's the word you were looking for, which means I have to acknowledge that this project is receiving funding from the EU Commission. With that out of the way, I would like to underline that this is a brand new project. I'm just starting to work on, actually I started 6 weeks ago. So I'm really using this forum to discuss and brainstorm on some ideas I'm digesting on right now. And I very much look forward to hearing your comments, questions or reflections. Come on, work with me. There we go. So the paper, much like the presentation, is composed of 5 parts. After a brief introduction, I will provide a very short overview of the military AI and introduce a distinction which to me is crucial between decision support systems and decision-making systems. Then I will use these 2 categories to analyze how the law of state responsibility applies to each of them in turn. And I will close with some ideas for future research and potential way forward. So I was really planning this presentation with having Agata speak before because I'm familiar with her paper and her work. So I didn't plan to go into details of military AI, but let me just tell you that there is a major discussion going on whether or not we are already in the middle of an AI arms race. There are different opinions on it, and I'm sure that political scientists among us will have very strong opinions about it. To me, it is kind of secondary. But what's important is that AI is bringing a lot of change. In the way we perceive military affairs, it's been even called the third revolution in the military affairs after gunpowder and nuclear weapons. So that's kind of a big change. Yet the international community has been caught off guard pretty much when it comes to military AI. And one of the very few initiatives on the international plane is the group of experts, group of governmental experts on lethal autonomous weapons, which was set up by the state parties to the Convention on Certain Conventional Weapons. In 2019, they came up with the so-called guiding principles, which are obviously not a treaty. And there is much to be said about the principles themselves, but for our purposes, it suffices to say that they do not contain a definition of autonomy, and they do not contain a definition of lethal autonomous weapons systems, which complicates the discussion a lot, as you will see in a minute. What's uncontroversial, though, is that IHL applies to AI-powered systems, means and methods of warfare. What remains contentious is the issue of accountability for IHL violations with the use of military AI. And this all pretty much started back in 2004, when Andreas Matthias published his seminal article on the responsibility gap, when he determined that there is an increasing class of machines with so much autonomy that nobody has enough control over the actions to assume responsibility for them. And he called this phenomenon the responsibility gap. It caused quite a stir in the international community. And there have been many papers and studies published on the issue, but most of them, overwhelming majority of them actually, has focused on individual responsibility of humans. I would like to take a slightly different approach and say that as much as AI will create problems when it comes to individual responsibility of humans, we should not forget that there are other regimes out there. And I'm taking one of them, chiefly the state responsibility, to say that there is really no such gap, and there is no reason to demonize AI in this regard. So I start with a few assumptions, and a few clarifications are necessary here. First of all is that it is pretty much agreed upon in the scholarship that individual and state responsibility are concurrent and not mutually exclusive. So just because I say I focus here on state responsibility does not mean I make any statements on individual responsibility. Second of all, and relatedly, this paper deals with what I like to call a plain vanilla violation of principle of distinction, not the war crime of attacking civilians. And that's important because I do not want to enter quite an old debate on the international crimes of states. So we deal here with just the violation of principle of distinction. I do not go into a war crime. I do not go into grave breaches even. And finally, I recognize that this is just a fraction of a debate when it comes to state responsibility in relation to military AI. There is a bunch of very interesting issues to be discussed and analyzed. I'm focusing, for reasons of scope, right now on the post facto attribution of the violation to a state. And I do not go, for example, into pre-deployment obligations, obligations to review legality of weapons, means and methods of warfare. If you're interested into this aspect, a colleague of mine, Professor Claudia Kronowska, has a fantastic paper upcoming in the Yearbook of International Humanitarian Law, so do check it out. It's the next issue. Now, let's demystify military AI. I said before that there are a bunch of concepts that lack definition on the international plane. Funny enough, artificial intelligence is one of them. So what I've noticed in military studies papers, position papers, as well in scholarship, this is the definition that's most frequently adopted, which understands artificial intelligence quite simply as the ability of machines to perform tasks that normally require human intelligence. I mentioned before the comment about AI arms race. It pretty much started, the discussion on AI in the military domain pretty much started back in 2017, I believe, when China released a major grand strategy on the country's direction and said that it wants to be a leader in AI in general by 2030. So Russia quickly followed it, and the usual suspects like the US and NATO members. There is a little bit of a misunderstanding when it comes to military AI. in public press, a little bit in the scholarship as well. And you can see that much of the political buzz has been created or contributed to by the Campaign to Stop Killer Robots, which is an association of NGOs doing generally fantastic job, but on this one campaigning to stop, to preemptively ban autonomous weapon systems. You might have come across a short video they produced with killer robots, obviously. It blurs a little bit the debate and what we're actually talking about. It is important to remember that autonomy or automation, and I'm sure we'll come back to this conversation on the distinction between the two, has been incorporated into various military systems for decades, at least since 1970. What recent advancements allow for is merely a more integrated, synchronized functioning of humans and technology. It's also been in place for quite a while. This phenomenon is called human-machine teaming, and is predicted to be the future of warfare for a while. These recent advancements allow for AI to be incorporated into various components of military planning and operations. Some of them are sexy and we hear about them a lot. That's chiefly intelligence. Some are less so, and that will be logistics or military and casualty evacuation. It also leads to AI being incorporated into overarching command and control systems. But there is plenty of abbreviations because military love them. It is against this background that I would like us to talk about AI and military targeting. So there is a little bit of a reality check needed. What's believed to be already in place are the so-called ATR system, which stands for Automated Target Recognition. That is a technology that's based on pattern recognition and is capable of identifying targets based on target signature predefined by humans. What's non-existent yet, according to many scholars and practitioners, and according to some states will never exist, that's chiefly the UK, are laws, which is a system that's once activated can select and engage targets without further intervention by a human. I mentioned in the beginning that we'll have a problem within the discussion what's already there and what's not. And it relates to the fact that modern contemporary targeting, it's a complex multi-step process. It's not a simple kinetic action as it used to be. And as lawyers especially like to think about, it is a process. And basically the discussion relates to how many of the steps are delegated to a machine and which are left to humans. So the way I see it, and I would be more than happy to hear your comments on this, is the core issue can be conceptualized as the following question. How does the outsourcing of certain elements of the targeting process to an AI-powered system affects accountability for a potential target misidentification? Because, well, we only talk about responsibility when there is a misidentification or violation. So let's use a little scenario to illustrate the problem. Let's imagine an ASAP-like situation. So that's model, well, we all know what. Let's imagine a situation when a state A is part of a multinational coalition in state B, where an armed group C is fighting the government. And our state A, the main actor throughout this scenario, protects this military base near the front line with an ATR system incorporating adaptive AI. And adaptive AI is a kind of technology which accepts the feedback it receives from the operating environment and acts on it to make data-informed predictions. So now, after a series of strikes operated by state A soldier, the system is capable of learning to identify persons without a uniform, entering a certain parameter from the base with a firearm as a target. So basically, the distinction is if you are one of ours, you wear a uniform if you carry a firearm. If you carry a firearm without the uniform, you are a target. And now imagine that one evening, the armed group C attacks the village, and the villagers flee to the base to seek refuge, but they bring hunting rifles for protection. And as they approach the base, the ATR system identifies them as a target. Now, let's complicate the things a little bit and imagine two options from now on. In the first one, which I will call the human-machine teaming, we have a soldier who follows the system suggestions, even though it's only, again, technically a decision support system, not a decision-making system. And our soldiers launches a strike at the approaching group without properly validating the target, which they should have done. But that's a separate conversation. And the second option, which is, according to me, futuristic, a lethal autonomous weapon system incorporating not only the AI-powered ATR, but also an armed drone, fires at the villagers without any human involvement whatsoever. Let's entertain this possibility for a while. Now, another twist. In both prongs, the approaching, not DPHing civilians are a direct object of the attack, and the large majority of them dies. And here's an assumption I would like to make to simplify the following analysis, and I know it's objectionable. Let's assume that all the precautions were taken. So we focused the discussion and the analysis only on the principle of distinction, just to make it easier. Now, how does these two scenarios fit into the regime of state responsibility? A brief, very, very brief intro to state responsibility regime. It's been set forth by an International Law Commission in the 2001 Articles on State Responsibility. The International Law Commission worked on them for 50 years. It's widely regarded as reflecting customary international law, and it's pretty much accepted as a given that these are the pillars of state responsibility. The fundamental premise of the ARC, the Articles on State Responsibility, is that all states are responsible for their internationally wrongful act, and two conditions need to be met for a state to be held responsible. The first one is that a conduct consisting of an action or omission needs to be attributable to the state under international law, and the second is that it needs to constitute a breach of international obligations of the state. So far, so good. It's important. It's quite simple. What's important to note is what's not there. So the regime of state responsibility is not premised on causation or harm requirements, which distinguishes it from many, many regimes of responsibility in both international and domestic law. Importantly, attribution, which is the first requirement, attribution is a pure result of law. And the mental state of acting individuals is irrelevant. And that's a crucial observation I would like you to bear in mind. But here comes the twist. Then the International Law Commission, while working from 1950 to 2000 for 50 years on this regime, did not envision responsibility for an object. So it states, it's everywhere in the articles and the commentaries, this fundamental premise that states act through humans, period, end of story. So I selected just one of the quotes from the commentaries, and you can see at the bottom of the screen that an act of a state must involve some action or omission by a human being or a group. So what do we do with this? Let's come back to our first scenario. Remember, that's a situation of a human and machine teaming, and examine both elements. And the first element, the attribution, does not really cause many problems. Soldier is always a state of an organ of a state, I'm sorry. So their conduct will always be attributable to the state, even if they contravene the instructions. There is no discussion here, whatever a soldiers or a battalion does, it's always attributable to the state. There is a little bit of a problem though, with the breach element, because it remains unclear, and I was surprised to find out that it's still unclear. It's whether or not a mistake of fact excuses a violation of principle of distinction. In other words, whether a mistaken attack on civilians is still a violation of a principle of distinction. So the question is, does the principle of distinction include an embedded subjective element, or is it a purely objective rule? Some arguments, more or less convincing, have been presented in support of both interpretations. I must say that I'm leaning towards the interpretation which perceives and construes principle of distinction as an objective rule. So if we talk about it from the legal theory perspective, it would mean that principle of distinction is an obligation of result, not of means. And I examined Articles 48 to 52 of AP1 and Article 13 of AP2, as well as what you have on the screen, the first rule of ICRC customary IHL database. And it's pretty clear to me that this is an objective rule. What's marked in yellow is, I think, the most obvious part of the rule. If the rule says attacks must not be directed against civilians, to me, it's clearly objective. I'm sure that we can have a very interesting discussion about it. But for now, just bear with me and assume for a minute that the principle of distinction is an objective rule. So that would allow us to make a distinction between grave breach, which needs to be willful, and the principle of distinction, a violation of which can be mistaken because it's an objective rule. I'm sure there will be many questions about it, and I'm more than happy to come back to this in the Q&A. So I'm sorry, that would mean that if you agree with me that the principle of distinction is an objective rule, this first prong of our scenario, which is a human-machine teaming, does not lead to any major obstacles, does not create any major obstacles when it comes to attribution of state responsibility to a state. There is no further finesse needed here. These actions would be plain and clearly attributable to the state fielding the weapon and sending the soldier to combat. Now, what happens when we take the human entirely away from the process? So let's try to apply state responsibility to future potential AI-powered decision-making systems, assuming that will exist at some point. So we just discussed the breach element, and let's keep assuming it's met. So a mistaken attack directed at civilians breaches the principle of distinction. But now we run into a problem when it comes to attribution element, because as I mentioned in the beginning, in the traditional reading of ARS, there is no mention of objects, which means there is no general responsibility regime for states' objects. We do have some very self-contained narrow regimes, for example, in space law, but there's no general regime. So what are our options? I see three, maybe you'll see more, and I'm more than happy to hear your thoughts on that. But on the plain reading of ARS, I see three options. The first one, the easiest one, is Article 11, which allows the state to adopt any conduct, whether attributable or not, based on different rules, as its own, to the extent the state decides to do that. I don't think it's a viable option from the political perspective, chiefly because states don't like to acknowledge that they did something wrong and assume responsibility. In general, this gets even worse in situations of armed conflicts, when what's most likely practiced is providing civilians with ex gratia payments, so discretionary payments without any admission of liability. What are the other two options then? The first one would be the Composite Act, covered in Article 15, and the other one is the concept of an agent. Let's look into the Composite Act. This notion goes back to something I'm sure Gata will discuss very soon as well, is this idea that no matter how independent, autonomous a given object or system is, they will always be the product of a human decision. So we have to remember there is always a person, a natural person at the end of the chain. some might be tempted to extend the underlying wrongful conduct to include this person, whether we decide it's a commander or a designer of the weapon. I was very tempted to throw Article 15 here, but it's completely unreadable. If you're interested, please check it out. It's a very complex provision. But in essence, the Composite Act is a series of actions or omissions defined and aggregate as wrongful. But the ILC made very clear that it construed the Article 15 to cover breaches of obligations which concern some aggregate of conduct and not individual acts as such. And that it would cover situations when a policy or repetitive action is needed to establish a violation. So think obligations concerning genocide, apartheid, or crimes against humanity. Now, based on these comments, it is my inclination to say that Composite Act is not, nor should it be, a legal vehicle used for stretching the underlying conduct to capture an act or omission by a human forming part of a state apparatus. And the reason I'm saying this is, think what would it do to the whole regime of state responsibility? So imagine a situation like Nicaragua. If we stretch the underlying, we're all familiar here with the Nicaragua case. If we stretch the underlying conduct, which forms the basis of an internationally wrongful act, to include, let's say, I don't know, an operative, the CIA headquarters, which is clearly an organ of a state, the entire effective control test used for attribution is useless. We can throw it out of the window. So stretching the underlying conduct is a very risky endeavor, which risks destabilizing the entire regime of state responsibility. But again, I might be wrong here. I'm looking forward to hearing your thoughts. Let's look into the alternative, and I'm aware it's also controversial. I'm tempted to conceptualize and look deeper into the notion of an agent, which does not appear in the articles on state responsibility. It is referenced often, however, in the commentaries, usually in the phrase organs or agents. But again, it's not defined there. But we do have a definition of an agent. It comes from the ICJ advisory opinion on reparations for injuries from 1949, where the court stressed that it understood the word agent in the most liberal sense, that is any person through whom a state or an international organization can act. Now, the way I read it, there is nothing in the literal meaning of the phrase, the definition, or logically that would prevent us from extending it to include objects, non-human agents. But again, I'm sure we'll come back to this in the Q&A. A few concluding remarks and the way forward. It is my belief that violations committed with the use of contemporary AI, that is human-machine teaming we discussed in the first prong of this scenario, can be easily attributed to the state fielding it. The existing legal concept of an agent can provide a legal avenue to be explored in the future when it comes to fully autonomous systems. And this is an important caveat I need to make right now, especially in the interdisciplinary crowd like this one. The term agent and related concept of agency have completely different meaning in law, especially international law, than it does in sociology. So it's important to say that I do not mean or imply it should be done that constructing objects as agents should mean that we should give agency and the sociological meaning to machines, or that we should give them legal personality. I do not suggest that. Now, with this caveat out of the way, let me just throw out there 3 questions I would particularly like to hear your thoughts on. And I'm aware that this is just the tip of an iceberg. So the first one would be if we assume that the concept of an agent can be extended to include non-human agents, such as lethal autonomous weapon systems, what would the mutatis mutandis application of attribution principle regulating the responsibility of state organs to non-human agents entail? So basically, what would application of principles designed to regulate human behavior to machines mean? The second question is to what extent can domestic laws on principal liability for torts of agents be used for inspiration? And again, we should never translate simply domestic concepts into international law, but we can look there for inspiration. And finally, what else can state liability for objects be based on, if none of the above? I came across a recent EU study which tried to link it with domestic concept of liability for domestic animals. It's there very early on, but it's another food for thought. So that would be it from now. I very much look forward to your comments and questions, and thank you for listening.
Thank you, Magda. It was very interesting and, of course, thought-provoking. I think we have a couple of questions and comments. Let's start with Kaya.
Okay, thank you so much. Of course, the topic is very close to my heart, but I have a question regarding your main focus. It means this responsibility for objects. And I was thinking whether you considered, this is something that came to my mind after the reading of your paper, how state is responsible for the consequences, for example, of the, let's say, critical infrastructure that is also an object and it can go wrong, like people can die because of the, I don't know, some major, maybe force majeure wouldn't be here the good example, but something can go wrong with this critical infrastructure, which is also an object, and whether state is responsible for that. Because you said that there is this cosmic, I think cosmic law, yeah, and
Space law, yeah.
Space law, exactly. Space law and environmental law that is a bit different. And don't you think that those are rather the regimes that we should look into, rather than the question of the agent? That's my comment and question. Thanks.
Should we take a few or should I answer one by one?
One by one.
Okay. No, the critical infrastructure is a great example, Kaya. And off the top of my head, because I'm still digesting this, we do have the state is often, I'm not familiar with all of the legal systems out there, but state is responsible often under domestic law for situations involving state-owned objects. It's just we haven't transplanted it into international law yet. As to your comment on whether we shouldn't look deeper into the self-contained regimes of space law or transnational harm, I don't have a firm stance on this. I need to reflect on it more. It seems to me that they were designed in such a specific circumstances that extending them to a completely different field might be tricky, but it's definitely something worth looking into, and I do keep it in mind. So yes, thank you for this comment. Definitely something to be done.
Leah.
Thanks, Magda. I really liked your paper, and I'm convinced that agency is the right way to go.
So you are or you aren't?
I am.
Oh, excellent.
I'm not convinced on the objective view on distinction, but that's probably because I was in the military. But I did want to understand more about why, and it may be just because it was a truncated argument in your paper and presentation, why I get the sense that you're saying that whether it's objective or subjective in terms of distinction has something to do with attribution rather than wrongful act. I don't, if that's the case, I don't understand. And if it is just about whether it's a wrongful act or not, I don't know why that has an impact on your main purpose here, which seems to be attribution.
I'm really glad you brought it up because it means I didn't explain myself well in the paper or in the presentation. It's absolutely not part of the attribution. It's whether or not there is a breach in the first place. So yeah, the regime of state responsibility remains an objective one, but we need to decide on the nature of the principle of distinction to determine there is, a breach to be attributable to anyone. So I do need to rephrase it if it doesn't come across clearly. Thank you for this.
No, I think, I mean, if you were in a situation where you were asking an international body to adjudicate a matter, right? Those would both be facts that they would try to assess. I don't think you would need to get over the wrongful act hurdle first before you had to address attribution. I think those would both be dealt by a decision maker, or so I don't know that you need to resolve that question here in your paper. Right. Because I think your main purpose is deciding whether anything can be attributable to
exactly.
And then that question is rather separate. So I think because at page 13, you say none of the proposed rules of attribution will be relevant, however, but I don't think that actually is, I don't think one is necessary to the other. You're just talking about attribution. So I think you can probably even set it aside here.
Yeah. No, this is a great point. Thank you. I will definitely rephrase this sentence.
You're welcome.
Thank you.
Zeno.
Hey, thank you. I really enjoyed reading your paper, and I see that the point where the panel is divided is basically your conclusion about this agent theory. So I'm actually a bit worried about this conclusion, because for me, the definition of being an agent means that any person who acts on behalf of a state or who exercises some parts of state jurisdiction or state power. But in the definition, it's one constitutive element to be a person who acts. And in my sense, it would humanize or personalize the machines who cannot perform actions. They rather just function in a way. And I don't think that they have such a cognitive functioning to be able to be agents of a state. So I think that being an agent means that the agent have to have kind of intent or kind of high-level cognitive functioning in a general sense, whereas the objects or the machines may have a really advanced cognitive function in one separate level, but cannot have a kind of overall cognitive functioning. So, for instance, it may have a really advanced cognitive functioning to observe and identify weapons, but it cannot assess the circumstantial elements of a situation. So I think that being an agent means that it must be a person, must be a human being, and this is why I think that it's rather the space object idea which could be an asset in finding the state responsible. Because I think that the space objects perform some kind of malfunctioning, and therefore satellites can collide or satellites can fall off and cause damages in the territory of another state. Therefore, it basically is an accident. And in my point of view, an AI military device can perform such kind of malfunctioning by accident. And for me, it resembles more to the malfunctioning of space objects than, for instance, intentional actions of an agent. This is just a comment, which were rather long. But I think that the space object or even the Composite Act would be more appropriate for state responsibility than extending the notion of an agent to machines.
Which is fair enough. As I said in the beginning, I'm still reflecting on all of this, and this is a very much welcome comment. And listen, the concept of an agent was created by the, well, not created, but used by the ICJ to cover the actions of humans, obviously. It was back in 1949, obviously, they meant humans. And I do understand that this could be a controversial idea. Just one of the, I'm testing the waters here. So I will definitely come back to the Composite Act. And pretty much what you said about space law links back to what Kaya said. Yeah, and I very much like the analogy between accidents that happen in space law and that malfunctioning of AI-powered weapon systems can be construed as also simply as an accident. So there is a link there to be explored. We'll definitely do that. Thank you.
Okay, and we move to Fabiano.
Okay, as usual, please overlook my legal ignorance. A few more philosophical comments.
That's much needed as well.
One is, I think, one important thing I feel like it's making the right comparison. So why would autonomous AI weapon be worse than humans in terms of accountability? It seems that in the end... Can
you say it again? Why would what?
Why would autonomous AI weapons, such as the laws, as you define it? I'm not sure if what I'm meaning here exactly mirrors what you refer by laws, but let's use a loose term here. So humans can still be accountable for it in the end, such as neglect implementing a reliable system at minimum, especially if mistaken attacks happen more than if you wouldn't implement that. And it can be less biased than humans. And as long as it doesn't have the same biases as humans, it would be helpful, even if it's just slightly less reliable, because those could cancel each other, especially in situations where humans couldn't decide in time. And sort of a worst case scenario for AI that I remember reading about in a recent manuscript by ecology would be the fact that the AI couldn't account for residual wrongness in actions. For instance, the need to give retribution to an innocent civilian's family when was required to kill in saving many other lives. So this is the kind of situation that AI could make decisions in the future. And at first, I don't think it would be necessarily less accountable than humans or less reliable in making those decisions, especially if they have to be taken extremely fast. But one argument would be, okay, the AI would take the right decision there, at least morally speaking. I don't know if it would go with international moral law. But the sense that even though it did the best it could do at the time, something wrong was done, the AI wouldn't be able to handle that sort of wrongness. And my own opinion is that it seems like the AI could store that information in its system, that a wrong was made, and then eventually a human could assess that, and he could store that information even better than a human being. Human beings can forget things pretty easily, especially when it favors them. So a soldier that made that same action could be at least as likely as an AI, or at least a well-designed AI, to forget that the wrong was made. And so I think we have to compare how reliable and accountable AI would be to the status quo. So how reliable and accountable are soldiers and officers? I don't see how a well-designed or reasonably designed AI would produce less accountability. It seems to be more of a technical issue. And there are many legal details that are explored of when and how we can consider AI weapons accountable and how we have to change the law. But it doesn't seem like it's a in principle objection that, well, this is never going to happen, or this is always going to be a problem if the AI makes autonomous decision. And linking a bit with the concept of personal accountability, it seems like we think until we design an AI who is also a moral agent, then AI couldn't hold any relevant accountability. The bucket would have to stop with humans. Of course, they will have to change once AI, if that happens, which still seems extremely uncertain. I think it would, but many people disagree. We couldn't. You would have to go through a human being who designed it, who was at the minimum he committed neglect in implementing a system that had those faults that caused those wrongs. And it maybe in the I don't know, 10 years, 20 years, that will become a problem, but I don't see it becoming a problem right now. And what seems to be happening is that especially in social media, maybe in war that is also happening, there's a risk that people will pretend they're using AI, excuse them of responsibility or accountability, but we just shouldn't, we aren't there yet, so we shouldn't let those people get away with that. So the concept of agent, for example, being an agent with simple intention is unlikely to be enough for that the AI could be accountable. Dogs have intentions, but perhaps not like humans, but they have some form of primitive intention and they have some level of cognitive complexity, but we still find it's honorable, accountable if it kills someone. And I mean, it seems like in the future, making more the far future argument, if a machine is conscious, highly intelligent, and it's a moral agent, it seems there would be little argument against considering it a person in the sort of abstract philosophical sense. And I'm ignorant of much of the work being done connecting this concept of personhood to legal accountability, but I would expect that we eventually will have to treat these machines as something like legal persons, not perhaps the same as a human person, but we would have to give him some sort of accountability eventually. If that happens, of course, it might be technically impossible. But I think that stress even more the case that we are just not there yet, because people doubt that we even be there in 20 years. So the bucket will have to stop with humans. Sorry if my comments are a little bit messy.
No, that's fine. It was such an incredibly rich comment that I'm not sure what exactly I should reply to. And I would be happy to hear more of your thoughts in an email if you don't mind. That would help me a lot. So just maybe two aspects. One, you hit the nail on its head really, because there is a major discussion within the group of states interested in developing military AI, and those very much adamantly against it, whether or not it would minimize the suffering in warfare. So the proponents of AI in the military would say that it actually is designed to make fewer mistakes than humans. So in this way, I did not imply, at least did not mean to imply, that misidentification of a target in our specific case by a machine would be worse than a human. At the end of the day, it's exactly the same. When it comes to awarding, some sort of legal personality to machines, again, it's been a major discussion a few years ago. I have a feeling it's faded away a little bit recently, and we go back to, looking for links to hold accountable the recognized actors. But just recently, there have been 4 cases regarding awarding patent rights to AI. So it could be a start of entirely different trend. And interestingly, we have a major divide between, in this case, and I'm speaking off the top of my head, so you might want to double check me. It's somewhere in my paper. New Zealand and South Africa, which awarded patent rights to AI, and US and UK, which decided against it. So it might reinvigorate the discussion on e-personality of machines. I don't know where it will go. I don't think I have a firm stance on it just yet, but it's definitely something that's widely discussed in scholarship. But I'm happy to continue this conversation later on over email if you have time. Thank you. I think we have one more question from Kaya.
I'm so sorry, I don't have a question. I have a follow-up comment.
Go for it.
what Zhao started to comment is kind of the discussion that is pretty circular in legal circles, debate on artificial intelligence in general. And I just want to ask, why do you think that from philosophical perspective, AI eventually one day would have to be personalized, or we would have to award it some kind of a value? I'm asking, maybe my tone is not suggesting that, but I'm seriously asking, because I can understand why someone can attribute patent law to an AI, because it's linked with money. That money is, I'm so sorry, my Teams is crazy. Money is probably given to the author or someone who has copyrights over this AI, or it finances the budget of this AI, from which it can be, for example, the compensation for victims of the errors of the AI can be paid. But then in the context of armed conflict, and we have to ask what's the aim of the responsibility. I don't know how to quickly switch it off. I hope you don't hear my constant vibing. Sorry. So what's the aim of personalizing a machine? What would be this justice interest, or what would be the aim from philosophical point of view of personalizing a machine? That's my question. And a quick, maybe a stupid comparison that came to my mind is, we don't put dogs in a jail, even though animals have more of agency than objects, because they have bitten someone, a kid, or even killed. Yeah, sometimes they can be killed. That's true, the dogs. But we don't put them into the prison. We don't include them in the legal system. So I'm asking why we should do that with laws. And what would that bring to the system of justice if we were somehow going into the direction of focusing on those machines? So I'm asking just for philosophical perspective. So could you please?
I think that, yeah, I think that my caveat in the presentation wasn't strong enough, because I do not advocate for.
No, actually, that was a follow-up question to Zhao. That's why I.
Okay. Sorry, I do not.
Yeah, you don't advocate. I know that. But he, in his comment, he used how, I don't know how to virtually address people in the chat. You said that eventually that can be an option, and it seemed to me that you made a strong case that from philosophical point of view, it may be something that we are going in that direction. Well,
I'm really playing the devil's advocate here, because just because a person is not capable of having intent, doesn't mean it cannot have legal personality. Think state, think corporations. So we do have examples philosophically there, and neither a state nor a corporation can be put to jail. If I had to make an argument from a philosophical perspective, which I'm definitely not ready to make, I would start somewhere there. But yeah, other than this, I don't have a ready answer. I'm a lawyer, not a philosopher, and if I am, to answer a philosophical question, I definitely need much more time to reflect and read. But thank you for this.
Okay. Luckily, we have a respondent who've managed to adjust ourselves to the to the switch that we had to do. And so let me introduce shortly Katharine Fortin, and then I'll give her the time to respond to your paper. Well, her response will be based on your draft paper, Magda, and not on the presentation. Katharine Fortin is a senior lecturer at the Netherlands Institute of Human Rights at Utrecht University in the Netherlands. Her areas of expertise include the law that applies in times of armed conflict, international human rights law, international humanitarian law, armed groups, and legal identity. She is the author of numerous articles on these topics, and her monograph, The Accountability of Armed Groups Under Human Rights Law, which was published in 2017, won the Liber Prize Award in 2018. We are very, very thankful for her to come in and be with us today. And Katharine, the floor is yours.
Thanks so much. Well, I just got off my bike, but I've got my breath back, and I obviously haven't heard the questions I've already asked you, Magda. So it may be that I ask exactly the same question as somebody's already asked, in which case feel free to just say, you know, I dealt with that. I think I have, for the ease of going through it, I have, I don't know, about 4 or 5 points. So I think I'll just run through them one by one, and then maybe there'll be some time for you to reply afterwards. First of all, I'd just like to thank the organisers of this for inviting me. It's really a pleasure to be here. And also I'd like to thank Magda for your paper, because I really enjoyed reading it and thinking about it, and found it very thought-provoking. And there's no doubt in my mind that it's on the way to being a very strong paper. So I want to couch all my remarks in that preliminary remark. So what I have done, though, is try and think, because I think that's what you want from me, about aspects of the paper that could possibly be developed a little bit more, thought about a little bit more, strengthened, that kind of thing. So the first point I wanted to make relates to precautions, which to me is kind of screaming out of this paper, but dealt with extremely briefly, because in fact you rather explicitly sideline it, and you say somewhere that you're assuming for the sake of argument that precautions have been taken. And I think I would kind of urge you to give some more thought to this, and whether or not you can so easily sideline precautions like this. And it seems to me that perhaps it ought to have more prominence in the article, for a number of reasons. The first reason is that you say, well, first of all, you say, imagine that all feasible precautions have been taken. Now, if you're really going to go down that route, I would recommend you to perhaps amend your little factual scenario so that it's really clear what steps were taken. So, I mean, I can think of a few, you know, they might have used floodlights to light this dark night to see what was approaching. They might have used a loudspeaker, encouraging surrender, following therefore the obligation to verify what was it in front of them. So either I think you change your scenario to make it absolutely clear what steps were taken, but then also I do wonder whether in leaving it outside your analysis, you sort of place outside your analysis something that's quite interesting. Because I wonder, when talking about AI and targeting, it seems perhaps that the very most interesting aspect is precautions in a way, because the whole AI system, the intelligence that is computer generated, isn't helping pull the trigger, but to verify the target. So I'm wondering if leaving it outside, you miss some of the interesting stuff. So for example, it seems to me that you deliberately situate your case study in a situation of high ambiguity. So, you know, you have an insurgent group who you tell us doesn't wear uniforms, and you have a civilian population who you tell us are armed, sort of have guns to hand, let's say, and you tell us it's dark. So you tell us that there's a lot of ambiguity here, which would lead to a situation normally where heightened precautions would have to be taken. And I'm wondering, to me, this raised questions, interesting questions about doubt and IHL and AI and doubt, and whether AI will mean that we don't, doubt becomes a thing of the past, and how AI will deal with doubt. If it does become a thing of the past, will that be a good thing or a bad thing? These kind of questions were resonating in my mind. I also wondered whether you could sideline precautions to the extent you do, because I feel like the existence of the precautions obligation is rather intimately connected, not only to the principle of distinction, of course, but also to the debates as to whether attacks resulting in civilian deaths have a subjective element or only objective elements. And you highlight that, you mention that authors who argue that attacks against civilians do have a subjective element rely very heavily on the precautions assessment. So it seemed to me that maybe needs to be dealt with a bit more. I guess I'm also wondering, how often does the scenario really happen that you have, as you claim, impeccable precautions, an attack having been taken and still civilian deaths? It seems to me that possibly that doesn't happen so often, particularly maybe in a scenario like you outline. I was really interested in your argument, which I think is really at the heart of your conclusions on whether the rule is objective or subjective. And I think, this is fascinating because I expected myself to be able to have a strong opinion on this and found that I was like, I'm not sure. And, I think there are arguments both ways. And I already mentioned, I think this connects the argument of precautions. I felt here like it was a bit of a cop-out to kind of say, we can't draw a conclusion on this because the ICRC has not yet pronounced, as if we're all waiting for the ICRC to pronounce on the law, where, of course, they will also be digging for primary materials on this or academic scholarship. So it seemed to me that your piece actually offers a really nice opportunity for you to step into that gap and provide materials that might be useful for them, and look at some more primary materials. I was thinking, I don't know if you looked at the ILA study on the conduct of hostilities or the reports from the Yemen group of experts. It seems to me there must be clarity on this issue. And I think you need to dig into it a bit more. You might not want to, but I think you need to, because it's so pivotal to your conclusions. Mm-hmm. So that would be my thought. I would also, how am I doing on time? Let me check. I would also wonder if you might want to go back and have another look at your case study, the little one that you create. And I already mentioned one thing that you could change. But what I found really interesting reading it was you say that the system learned to identify people without a uniform entering a certain perimeter from the base with a firearm as a target. So at the heart of your case study is, of course, the DPH law. Mm-hmm. And, that's also a very difficult area of law where different states disagree, right? So what I would have found helpful, I think, here would have been to hear the position State A took regarding DPH, more clearly articulated. Mm-hmm. And perhaps even just in a footnote, a little bit analysis from you regarding your thoughts on whether a person without a uniform close to the base with a firearm might be DPHing, and if not, why not? What part of the DPH analysis is missing? To me, that would have been helpful. That would have been helpful to understand what mistake you felt was made and why. Mm-hmm. And I think you've thought it through, so I don't think that's going to be particularly difficult for you to add. But I think it takes the analysis a little bit further about what precautions or what safeguards can you put in place in such a system to make sure that this doesn't happen. I'm going to go on to the attribution bits in a minute, which of course is some of your most important arguments. But before I do, I wanted to raise human rights law, which of course doesn't appear in your article, I think at all. But at the beginning, you do, of course, put some areas of law outside the article. And I think, rightly, you kind of say, I'm not dealing with this, I'm not dealing with that, I'm not dealing with that. I think you need to mention human rights law, partly because the scenario that you write has some similarities with Jaloud against the Netherlands, for example. A car driving their checkpoints, behaving a bit erratically, the soldiers thinking that it's soldiers, and then shooting. So there is stuff in human rights law that could have been relevant had it been within the realms of your paper. So I would think about that. And if you decide not to mention it, just at least mention that you're not mentioning it. And now attribution. So you use the word state objects quite a number of times. which I found very triggering because I have a book on my desk at the moment, which I love, called International Laws Objects, which I presume you know. It's edited by Jesse Homan and Daniel Joyce. So it seems to me that there's an inquiry here that you don't go into, that you could go into, which of course relates to the last question you asked a bit about legal personality. And this is, I think you use the word objects more in a kind of literal meaning to me, like objects, but I think, you know, you can also think about it in a more grammatical sense. And I say that not only in terms of grammar, but the grammar of international international law. What do we mean by objects, and why, and when do objects become subjects? And it seems to me that if you're arguing that the laws should be an agent, maybe you are arguing that they are becoming a subject of international law, having a personality such that they are treated as a subject of some kind, in the same way as an agent, a human agent or official would. But I think it would be interesting if you sort of tapped into the discussion, partly because, of course, we do have precedents of other entities being treated as an object under international law and then becoming subjects, like human beings. You know, it's interesting to think that human beings were once objects and now they're subjects. So maybe, you know, maybe this is helpful. The animals analogy that was just mentioned also, you mentioned, but I think it could be more useful for you somehow. There's a new book coming out on animals in IHL, edited by Anne Peters and Jérôme de Hemptine and Robert Kolb. It should be coming out quite soon, but it might be interesting for you because a lot of the authors in it are dealing with similar issues relating to animals and DPH, actually. So, you know. My final comment is that in the attribution bits, one argument which I didn't see mentioned, which I thought could have been mentioned and would be interesting, is that of due diligence. So you've already mentioned, you know, we've already talked about due diligence in terms of proportions, which of course is another obligation of conduct. And you mentioned due diligence type obligations when you talk about transboundary harm. But I wondered if more couldn't be done in your argument about the sort of due diligence obligations under IHL, and I'm thinking about the obligation to ensure respect for. And then maybe you've thought about it and decided not to deal with it, but it seemed to me that this was a provision that was originally envisaged to cover actions by entities who weren't soldiers, you know, who weren't in the army, other outside entities, they were humans. Like, for example, individuals not belonging to the state, but fighting alongside the state. And somehow it seemed to me that this could be not too far of a conceptual leap to apply that to these weapon systems. And those are my comments. I hope that some of them are useful.
Thank you so much for this. It's incredibly rich, and I have a full page of comments. And I'm really glad it's recorded, so I can come back to this right now. Just a few remarks because I see we're running out of time before the next session, and I will start from the end. When it comes to the due diligence, I actually have a love-hate relationship with due diligence, and in this one, I just decided to exclude it. But I do recognize it would enrich the argument. I must admit, I focused so much on IHL that I completely overlooked IHRL, and it will definitely add meat and substance to the argument. So I will definitely do that. That's something I cannot read. Yeah, I was also surprised to find how little was written on the objective versus subjective rule of meaning and nature of principle of distinction. Frankly, I didn't have time to dig deeper. I will do that. But I was definitely surprised that we still have, that this issue is still outstanding. I did not mean to say that we cannot have as academics, as scholars, cannot have an opinion before ICRC, you know, makes a pronouncement on it. So I do need to rephrase this sentence if this is how it comes across. It's a very interesting comment to add in well, definitely I will have to revise the case study, and it was an easy way out to say that precautions were taken simply to simplify the analysis at this stage of the draft paper. But I very much like the idea to add the state A stance on the PHing. That's something I didn't think of, and I think it's brilliant. And there is one more major comment I cannot read right now. But we'll definitely come back to the recording of this session and all your comments. Thank you very much for making the time and providing me with them. That's extremely useful. Thank you again.
Welcome, Magda.
Okay. Thank you, Katharine. Thank you, Magda. I would like to add my 2 cents on the question of the subjective-objective element of distinction, especially. And we've had some talk about it, Magda. And no matter how I try to think about it, at the end of the day, I come to 2 conclusions. One, the laws of armed conflict must be operational and practical at first, otherwise it wouldn't be plausible to play with them during the chaos of an armed conflict. And the second one is the fact that the definition of a civilian under Article 50 of Additional Protocol 1 clearly states that in a case of a doubt, someone has to be presumed a civilian. Therefore, the question of doubt is embedded within the definition, which means it has to be some kind of subjective element to whether or not this person is a civilian or a combatant in order for me to attack. If I can't make any assumption of the status of the person, I have to assume that every person is a civilian, and therefore I wouldn't be able to attack. And therefore, if attack against a civilian is clearly a violation of international maritime law and a grave breach, it should be an attack against a civilian under the definition under Article 50, which means in a case of a doubt, I should have assumed that this person is a civilian. But if I don't have a doubt, if I have enough information to base my operation according to, then this is not an attack of a civilian, even though factually and objectively it is.
See, I'm glad you mentioned grave breach, because for me, there are 2 different provisions. I can see, and this would actually maintain the logic of having grave breaches in the first place. So we can imagine, that's the way I see it for now at least, and I admit it also fits my argument, so I might be inclined.
You know what, let me retract the grave breach. I don't care if it's a grave breach or not. Attack against civilians is prohibited. We can agree on that. Put aside the grave breach. But a civilian within the question of what is an attack against civilian must be in accordance to Article 50 of Additional Protocol 1, which define what is a civilian. And this definition includes the question of doubt. And this is what I care about. Put aside the grave breaches.
Yes, but just because a connected rule has an element which is subjective doesn't mean the entire principle of distinction is by definition subjective. I don't think so. I do have to reflect more on this, and just to come back to grave breach, I know you retracted from this argument, but if we want to have both, principle of distinction, plain and simple, and then grave breach, something needs to distinguish them. To me, what distinguishes them is the question of the mens rea, I would say, for the lack of a better term. So I know it's the wrong one. I just don't have a better one, off the top of my head. But
intent.
It would need. It's not the intent. It's definitely not the intent. Or rather, I would say that to violate the principle of distinction, you don't need any intent. Your mental state is irrelevant. For grave breaches, you need to act willfully, and then you have a never-ending discussion. What's the difference between a grave breach and a war crime, right? So for these 2, you need some mental element, being willfulness or intent, while for a plain, vanilla, again, violation of a principle of distinction, the mental state is irrelevant. But again, I don't have a firm position, much like Katharine said, I don't have a firm position on it yet. It took me by surprise when I looked into this that, after 40 years after AP1, we still don't have, a unilaterally agreed position on this in international scholarship. I will definitely look deeper into this, and I do one's position on this very much depend on whether or not the principle of distinction is analyzed independently or together with principle of precautions. If they're analyzed jointly, it makes the overall prohibition a subjective one. If you separate the two, and just for the sake of argument, even if it's, intellectual exercise, assume that we can have a situation where the principle of distinction is breached, but not the principle of precaution, I think that changes a lot in the situation. And I very like much the comment from Leah, who said that, once you've been in the field, you see it as a subjective one, which is very much true. That in practice, they often are applied jointly, right? But whether or not we cannot imagine a situation that only one is breached without the other, I think we can. I definitely need to digest this and think about it more. But to me, it boils down to whether or not they are analyzed jointly or separately.
Katharine, please.
Just to add, I think you try and separate them in your paper, but I think you do so, and I said this hopefully, in a rather artificial way, or at least it needs a lot more convincing to argue that you really ever could separate them. And I think in some ways, the very notion that you have the articles on precautions of attack might lead you to the conclusion that, and I think this is similar to what Ido said, that if you did have a scenario where you'd really taken all precautions, the natural conclusion might be then that you shouldn't be held liable for a violation. Well, certainly not of that obligation. But then your question is, yes, but what can you still be held liable for the result? I think in your analysis of this issue, which certainly needs to be dealt with very deeply because it really is so pivotal and difficult, I think it seems to me to be helpful for you to look more closely at this issue, because the principle of distinction you rely on is an obligation of result. So what you're saying is, okay, if the result is reached that civilians are killed, then you have a violation. But the obligation of precautions is an obligation, naturally, of course, of conduct. So how do they sit together? And what are the relationship between these norms? Do they have a relationship? Is one a way of interpreting the other? Or do they sit separately, as you just said? I think you need to clarify how you see this and justify your position.
I'm afraid you're right. It's just in this paper, I was trying, it kind of surprised me that I had to go into this at all. So I was rushing, and I have to admit, I was rushing for this part of argument to get to the attribution. But I see from your comments that it definitely needs more work. So I will do that. I will do that.
Leah, please.
Thanks. I'm just going to add the operational lens again, and that in practice, they are never separate, right? In practice, when you're applying the law, they are never separate, the precautionary principles from the principle of distinction. They are always operationalized together. And so, you're talking about telling either a state or an individual, you can do everything right and still be liable in the height of battle, right? And I think, like, from a practical standpoint, right, the law needs to work in the context that it was designed for. And I think the law of war recognizes that mistakes are made in that context. So while, you can read the law and say, armed attacks may not be directed at civilians. If I'm directing a drone attack, and I do not believe they're civilians, I'm not directing an attack at civilians, right? I'm following the principle of distinction in that moment. So I know we like to, as academics, theorize about these things, but IHL is operational law, and it was designed to be practically and purposefully implemented in war, lest it not be useful and we just abandon it. So I would ask you to consider that as well. And I think it doesn't mean that there can be no liability whatsoever. That's where human rights law provides some recourse, right? Under the right to life, the duties to investigate, etc. So I don't think it's well, if we don't, then there's no wrongdoing there can be found by anybody, and the lives are lost with nobody held responsible. I think that they can be, but I think under human rights law is the place there. If you really are complying with precautions, but not, ultimately the result is the death of a civilian.
I must admit that I'm convinced by this argument, as much as I didn't want to be. It would require, if I noticed that you read the paper, if we assume there isn't a violation, there is nothing to attribute. So I had to make this assumption to carry on with my argument. But now after this session, I will definitely have to change the scope of the scenario, which would allow me for, find a violation elsewhere. For now, I just needed a violation to, go ahead with attribution. But as I said in the beginning, I'm very much convinced by the operational perspective. So I'm not going to argue against this.
Thanks.
Okay, I think that concludes our discussion. We had some interesting beginning to our today's session. I think we overcame everything, and we had a very, very good presentation by Magda, a very interesting response by Katharine, and overall a very, very interesting discussion. I want to thank everyone who came to take part in this discussion, everyone of the students who joined us to listen to the talk. And if you want to listen to more talks of the Minerva Center and especially of this workshop, you can subscribe to our YouTube channel, and you can find the edited version of this talk on our YouTube channel, and as well on our Facebook channel, on our Facebook page, where we live stream all of our events. So thank you again, Magda, Katharine, and all participants. We are now going to take a 15 minutes break before the next presentation by Agatha. Thank you.
Thank you, Ida. Thank you, Katharine.